Now, the president suspended Judge Tshifiwa Maumela this week. It has a lot of implications for the Senzo Meyiwa trial, amongst other issues. Let's speak to legal analyst Mpumelelo Zikala to unpack this and give us further perspective of the future implications on this. Thank you very much for your time this afternoon, Mpumelelo. And I suppose the initial thought that everyone would have had when the announcement was made earlier in the week that Judge Maumela was suspended was, well, what's going to happen with the Senzo Meyiwa trial? Does he continue as the presiding judge, or does he step aside and have another judge go over all of what has been presented and have the trial start from the beginning? What exactly is it that happens?
Strictly speaking, he can continue. So he can continue to hear the matter. The suspension only means that there are no new matters that can be allocated to him up until the dark cloud of the Judicial Conduct Tribunal has come and gone. But he can certainly sit in that matter, be able to hear evidence and adjudicate on it, in as much as he is expected to finish all these other previous cases where judgment has not been issued. So it does not really affect on a strict basis the continuation of the trial. However, it may be recommendable or much better that he is removed at this earlier stage, just in case there are going to be complications at a later stage. You don't know what's going to happen if he is indeed found guilty and he said to stop listening to all these matters and or any other event that can then come in. Now, if you look at this fact and the unique circumstances of it, meaning that it has been 10 years since the occurrence of the incident or years ago, and it's only now in which we're only seeing people going to court and being tried on this matter. The question would be, do you really want to prolong it by appointing a judicial officer who has a dark cloud over their head, or do you just stick with the option of saying, let's start the trial again over, let's speak to the legal practitioners and say to them, this is what we are going to do. The Criminal Procedure Act does allow a system of admissions according to Section 220 or 220 admissions. Let's use those so that we don't have to recall all the four witnesses to state the amount of time in which they've stayed already. We can just curtail the evidence in which they're going to provide to the crucial ones, and then let's continue with the matter, with the vision of saying, let's finish this as quickly as possible. So those are the two options which are available. But strictly speaking, the judge can continue to hear this matter. It's not going to be affected in any manner, but it would be advisable that he be changed.
What about the suspension is so significant, Mpumelelo? Is it that abnormal for a judge to take 6 to 12 months to decide on a presiding matter? Or is it abnormal, as was initially argued when the complaint was initially put forward back in 2020? Just give us a sense of the anomalies that exist that would have constituted to the suspension that we're seeing.
The best practice is that a matter must be concluded after all evidence has been provided within 6 to 12 months, meaning after the evidence has been presented to you as a presiding officer, you have up until 6 or even 12 months at most, according to unique circumstances that would exist in that matter, to come up with a judgment. Now, there may be a myriad of reasons of why you have delayed, but that particular delay must be reasonable, in which the tribunal is going to sit and try and find out from the judge what's causing all these delays. Is there anything that you might need help with? Because you have to look at it from the side of the clients in this case being the litigant. They've been waiting for more than a year to hear what's going to happen in their matter. Some of them may even lose interest, and they're going to even lose interest in the implementation in the manner in which our justice system is working. So if you have certain things which are not going optimally when it comes to the access to justice, the administration of justice, it must be investigated and removed if it's a cause for concern, or all those issues to then be helped. Or if the problem is the presiding officer cannot sit down and write this particular judgment, let's call them and hear what's the problem, because at the end of the day, it is the clients or members of the public which are suffering. But to take more than 6 or 12 months, which is the norm, in terms of the issue in judgment, then it is a cause for concern and something that ought to be investigated.
Would the argument hold water here, Mpumelelo, that a lot of the judges, Judge Maumela and many others, are dealing with a huge backlog, or not just a backlog, but a huge number of cases that are coming into the system at a crazy rate, if you will, and it's becoming impossible for legal officers to not only preside over them, but to keep up with the level of cases that are coming through the court system?
Well, one cannot say there are no problems that exist. There are challenges that are there, but they can be overcome. Let's deal with the volume of work which is coming in. There's also the utilization of acting judges, which is utilized from time to time by the various judge presidents of the various provinces. So if the work is too much, it's becoming too much, there are many matters which are coming to you, then let's appoint more acting judges that can relieve the pressure from the normal fully appointed judges. I think that's the first intervention that can be there. The second one is to then say, maybe let's look into the way our justice system is working. When it comes to admissions, mediation processes, and all those things, maybe they must be utilized more so that we're able to alleviate the pressure from our judges. But the most important one is this. A judge works similar to that of a school term. So there'll be a number of recesses in between the various court sessions that are there, which are intended to then say, because we've been hearing matters from for the past 2 or 3 months, every single day, let's give you an amount of time or these particular months to actually be in your chambers, not listening to any new matters or any new evidence, but in which you are going to deal with the matters that were heard earlier. Now, that's the time in which you then sit in, you draft your judgments, you do your research, and then you come up with the judgments at the end of that recess or at the end of that session. Now, the question would be, if all these interventions are not working for you, what type of request did you have with your judge president? Because it's a normal working relationship. If you have a problem, you go to your immediate supervisor. So if a judge has a problem, they must go to the judge president and say, Judge President, I'm finding it very difficult to stick to my required schedule. Hence, there's going to be a delay in a manner in which I'm delivering my judgments. If the issue is with researchers, then let's find innovative ways of being able to deal with those, and not to make members of the public wait for long, considerable amount of time before they get an outcome of what is happening within their matters.
Thank you very much for those insights. That is legal analyst Mpumelelo Zikala joining us there to give us a sense of what happens to the Senzo Meyiwa trial, but also just a broad sense of what it means that Judge Maumela was suspended by President Cyril Ramaphosa earlier in the week. Still